Good morning, and may it please the court. Bill Burgess on behalf of Alan Butler. I believe I've reserved 5 minutes for rebuttal. In light of the court's, gotta be careful. In light of the court's recent decision in United States v. Blackman and the 28J letters on that, I intend to focus this morning on the first issue in our briefs, the district court's calculation of loss and proceeds for sentencing, restitution, and forfeiture. And as we describe in the briefs, in this case, Butler presented evidence that over the course of 8 years he performed some.
I take it from that you're conceding the Blackman issue.
I think we have to. I mean, we explained in the letter the court probably didn't have to reach the issue, but it's hard to say that the court did not, in fact, reach the issue, and we think it did. I mean, there's the paragraph at the end of the opinion. If that was all there was, we'd say it just kind of hangs out there and it's unnecessary, but the government cites some of the other language in the opinion that seems to bear on this. And you know, again, we don't think the court had to reach the issue, but we do think that the court did reach the issue in Blackman. And that's why we reserved whatever rights we still have after that. So as to the first issue in the briefs, and Butler presented evidence over the course of 8 years. He did some 1,900 hours of manual labor after hours. And this wasn't just cleanup and pounding nails. This was using his own construction equipment, building walls, digging trenches to perform Valiant Act subcontracts. And the district court said a couple of different things about that, but the court accepted that testimony for the sake of analysis, but still gave Butler zero credit in terms of his sentence, forfeiture, and restitution. And we submit that this was error. And the district court gave, we think, two reasons for this. The first one is the one we
found it interesting there. His own company didn't give him any credit because apparently it took no tax deductions at all for any of this, except for what it physically paid the other subcontractors.
I think that's correct. We don't dispute that. I know the FBI agent did get into the tax records and said there was some indicia that Valley was operating as a legitimate company and in fact performed other contracts that weren't part of the calculation here. But yes, as part of, I believe the record reflected that as part of concealing his ownership of Valiant Act, he did not have Valiant Act pay himself pay Mr. Butler a salary. He mingled their funds with his funds. But again, the district court didn't get into this and didn't rely on this, and so this isn't the situation of like a black box jury verdict where you look to see if there's evidence that could have supported the ultimate conclusion. I mean, that is a bad fact for us, but we don't think the district court relied on it. And we think that the district court did do was give two reasons for this. The first was the legal reason that we focused on in our briefs, and this is the actus reus part of Butler's crime. The district court's reasoning is contained in a number of orders, but we think the critical part of the analysis is in two paragraphs. There's the one straddling A308 and 309, and A309 and 310. And there, the district court says at A309 and 310, assuming for the sake of analysis that Butler actually performed manual labor as he contends, it did not provide legitimate value to CHC. And he says that Butler's labor was specifically performed with the intent to profit at his employer's expense. It was the very essence of the criminal conduct to which he pled guilty. And we think that's wrong under this net principle we've talked about. We don't think the government defends that part of the district court's reasoning. This was part of his scheme in some sense. I mean, he pled guilty to concealing the ownership of Acton Valley from his employer, and he did say that he profited from that. But that doesn't mean that the work he did for Valiant Act didn't provide legitimate value to CH Construction. We think that part of the district court reasoning is an error. The second reason the district court gave, and I think this is the part the government focuses on a bit more, is where the district court says, well, this was part of Butler's contractual duties to CH Construction. And again, the reasoning is in a bunch of different places. We've tried to pull it together, but we think it's most explicit at A351, which is the order denying the stay pending appeal, where the district court says, that this court found that defendant was not entitled to an offset for his services because any services he provided fell under his contractual duties to his employer. And then at A409, this is remarks on the sentencing transcript. He says, his job was not only to oversee the construction, but also to supervise the subcontracts. His job was to get it done. If he chose to do it himself, so be it. And we think if that part of the ruling stands, it raises important questions that arise every time a salaried employee is convicted of a crime involving self-dealing. And the district court doesn't get into the contractual language, doesn't get into the evidence. He seems to find it sufficient that Butler's a salaried employee and that he was in some sense overseeing the operations. I mean, he was ultimately responsible for making sure that these jobs got done, but that doesn't mean that he owes CH Construction every waking hour of his day, and that work he does after hours, and he's an executive, he supervises the projects, and then he changes out of his executive clothes, and I said earlier, it's not just pounding nails and cleanup work and incidental stuff that you have to do as part of management. I mean, he provided evidence, detailed notes of work he did, including construction of walls. There's a picture of the actual wall. There's a picture of
Mr. Burgess, the litany of things that you say, I suppose they come in somewhat undisputed. He says that, but the problem you have though is the other people who did the work said as testimony we did, or the people who are continuing to do the work after he's out of the picture, said we did the very same thing that was done on these projects, and we did it for a considerable amount of money less. So that's evidence that works against that value added that he said he did. And this preponderance of the evidence, isn't it in the standard?
It is a preponderance standard, but
So don't you lose in the sense that you had your shot at it? Okay, you said you gave this value added. Court had no. They said no. We did everything on this project, even punch list things, which is very key. Even list things, and we did it for a whole lot less than what you paid him. Isn't that probative, proper evidence that counterbalances his, and therefore the trier of fact to find it was more, it weighed more? Why is that wrong?
I think two responses to that. I mean, there is evidence on the other side of the balance. I mean, our first point is that the district court didn't rely on that. And this, again, it's not a black box jury verdict where you look at the evidence that could have supported the conclusion. It's what did the district court actually...
It's in the record, isn't it?
It is in the record,
We
yes.
can affirm on grounds that are in the record, can't we?
Not...
We can?
I don't think so in this
I
particular...
thought we could. Go ahead.
Okay, so in the context of summary judgment, that's a legal determination, and you can affirm on any ground not support it, that regardless of what the district court relied on, because that's a legal conclusion. In a jury verdict, it's a black box. You look at the evidence. But in this case, this is a district judge applying his discretion, determining the loss, and figuring out an appropriate sentence. And I think if the district court didn't rely on a particular piece of evidence, the fact it's in the record is not the end of the analysis. And we addressed the evidence on the other side of the scale in our reply brief and in the opening. The people did say what they said, and that we can't really dispute that, but
Well, is it a credibility issue?
if the district court had made credibility findings, then we'd have a much more difficult time. But I mean, the district court said, accepting that he did this for the purposes of analysis, and the district court relied on two reasons. One was this actus reus thing that we got into, and the other thing was the district court's contention that it was part of his duties to CH Construction. And I think when the district court makes a finding in the context of a sentence in this procedural posture, you look at the district court's actual reasons. And the evidence that supports the idea that this was part of his contractual duties he submitted is just not there. And
Was he being paid?
Was Butler being paid? Yes.
Okay, and did he do it while he was still in their employ?
Yes.
So what's the problem?
The problem is the implicit premise that Mr. Butler owes his employer every waking moment of his time.
Not
because
every,
he's
but things that you do on their behalf and you get paid for, why is that not embraced in that?
well, it's what he got paid for is the question. I don't think he got paid for. He has a salary and he works for CH Construction and he has responsibilities in connection with his title at CH Construction. But his responsibilities are an executive, to oversee the projects, to hire subcontractors, and that sort of thing. And if he goes above and beyond and is driving construction equipment and building walls after hours, and the district court didn't say, I don't believe you did this stuff. He just said, I think it's within the scope of your contract. And the point is, the district court just didn't get into the details of the evidence. The district court didn't parse.
Is there evidence that it's not in his contract?
Is there evidence that
These things that he did is not within his employment contract?
the employment contract, it's at 87 to 91, is nonspecific. There's a title, there's a non-compete clause, and there's a clause that says that so long as Butler is not in competition with CH Construction, nothing herein shall preclude the employee from pursuing other business, charitable, or investment activities, as long as the activities do not infringe materially on the time the employee has to devote to the performance of the obligations set forth in the employment agreement. And if he was, that doesn't nail it shut, but his actual employment contract is vague. It says nothing about manual labor. It describes only executive functions to the extent it describes any functions at all. And there is this at least implicit recognition that he doesn't necessarily owe CH Construction every hour of his day. We have to concede the government did present evidence on the other side of this, but the district court did not rely on it, and we address in the reply brief why that evidence is not sufficient to support the result. So I'm out of time. If the court has any further questions, I'm happy to answer them. Otherwise, I'll reserve the balance of my time.
Thank you.
Thank you.
Thank you, Mr. Burgess. Ms. Mickelson? Can you address that, Ms. Mickelson? He said, the counsel said that the district court has left us sort of cabin to just the basis that he ruled against. That was solely because he felt these were in the scope of his employment. Is that correct?
And may it please the court, I'm Jamie Mickelson representing the United States. No, Your Honor, that's not correct. The district court here, and this is exactly the reason that the government in its brief highlighted the fact that this is a clear error review, because this was fact-finding by the district judge. It was fact-finding that was completed after a 7-hour sentencing hearing. The judge here heard testimony from 5 different witnesses, read extensive briefing ahead of time, received numerous pages of documents, and a few days later had another, I think, 2-hour hearing on the forfeiture issue. And there was essentially 9 hours worth of evidence in front of the district judge. The district judge various times made factual findings throughout the record, but the fact is that just because he doesn't specifically say what he did or did not rely on, what's in the record is in the record. And as Your Honor pointed out, the evidence here was that the government's burden was to prove at sentencing the loss amount by a preponderance of the evidence. There was 2 competing versions of the evidence that were presented. One was the government's theory of the case, which was that essentially any money that was not paid to these subcontractors was the loss amount in the case, was equivalent with the loss amount. And that's what the district court ended up agreeing with. And I think as the court pointed out earlier as well, that was supported by the testimony of Agent Holzer. It was supported by the tax records and the bank records that were submitted in this case. All of the contemporaneous records to this offense supported the government's position and supported the district court's finding here. To the contrary, the defendant took the stand and he testified about this work that he claims to have done, and he presented the expert report of Dr. Perrin, although there was no testimony from Dr. Perrin. So the district court was left with 2 competing decisions. Did it believe the government's version of events, or did it buy the defendant's version of events? And the district judge, in his role as a fact finder, made the decision that it was relying on the government's versions of events, that it agreed with the government's version of events, essentially. And that is a factual finding that this court should review. In the Stevenson case, talks explicitly about the importance of the clear error standard and why it matters. And it's because the district court was in the position to hear all of the evidence and to review all of the documents, and was in the best position to really make the determination about what actually provided value to the victim company in this case. And I think that's what's important to understand at the outset, is there's no dispute about the guideline in this case. Everyone agrees that 2B1.1 was the appropriate guideline, and everyone agrees that under that guideline, the defendant should get credit for the fair market value of the services received. And so what the district court had to do in this case was determine what is that fair market value. And after hearing all of this evidence and seeing all the records, the district judge made the decision that the fair market value was the amount equal to the amount that was paid to the subcontractors, was the correct loss amount in this case. And again, I think I stated before, but just simply because the district court didn't highlight everything specifically doesn't mean that the district court didn't rely on it. The district court heard all of the evidence, commented on the evidence. The district court did specifically make several specific credibility findings. It first of all did credit the testimony of Agent Holzer, and specifically found who is the FBI agent that went through in detail these bank records and the tax records of the defendant's companies. And the district court specifically credited the testimony of Agent Holzer and said that it convinces the court that the markup of subcontractor services was considerably higher than the prevailing market rate. And that was the heart of the issue before the district court. What is the fair market value of services rendered? And that's how the district court answered that question. It credited the government's testimony. the district court essentially did say, I'm not going to make a decision about whether you did or didn't do the work. The district court several times sort of indicated some skepticism, saying, I'm not so sure that you did it, but assuming for the sake of analysis you didn't provide legitimate services to the victim company. And that finding was correct, because this is a situation where the defendant was the director of construction. He was already on these job sites, and he was responsible for making sure that overseeing all of the approximately 30 to 40 subcontractors that worked on any one job. And he was responsible for talking to all of them, giving them the punch lists, and going back and making sure that everybody did what his company, CH Construction, had contracted for them to do. What he did here was decided to award contracts to his own company, and then even if you believe the defendant's evidence, he decided to go around and do things like prepping the site for the stonework, doing the cleanup work for the stonework. And that is something that was already, that he should have been enforcing other people to do. So it's not a situation where I think the phrase that was used was he's supposed to devote every waking moment. And that's not the case at all. Certainly CH Construction never took the position that he needed to be on site 100 hours a week and that he was supposed to do that. But what the district court found is correct, is that he was responsible for delegating these responsibilities, for supervising them, making sure they got done. And what he did here was devised a scheme to profit at his employer's expense. And he decided, rather than doing my job and going to these subcontractors and telling them, you need to do the work that we've already paid you to do as part of the contract, I'm going to just do it myself, and then I'm going to decide how much to pay myself from my employer. So he was essentially on these same job sites, working for two separate companies at the same time, working for both CH Construction and Valley or ACT, depending on the job, and he was getting paid all by CH Construction. So he figured out, and the district court stated it very succinctly when he said that he figured out a way to double his salary by performing work that either was already part of his job in terms of supervising and making sure it was done, or was already part of another subcontract. And so the district court's finding here was based on the facts, based on the nature of this defendant's job, based on the nature of the work that he claims to have performed, and found that based on all of those facts, any work that the defendant claims he did provided no legitimate value to the victim company. I will note, and this is something that I neglected to note in my brief, but even adopting the defendant's argument, one of the issues that the government had throughout these proceedings was that the defendant was never able to say what the value of any of his work was. It wasn't until, I think, 2 days before sentencing that for the first time we got this expert report that tried to sort of quantify the actual value of the work he had performed. And up until that point, that was the frustration, as the government said, the tax records don't account for his work. The bank records don't account for his work. There's no evidence that he did any of this work, so there was no way to account for it. And he finally did attempt to account for it in this report by Dr. Perrin. Even in that report, Dr. Perrin categorizes various different, he categorizes the self-performed labor, the materials that the defendant claims he purchased, the cost to the vendors, things like that. Even in that report, Dr. Perrin, who is the defendant's expert, states that the value of the defendant's self-performed labor was $330,000. It did not make up the difference of the ultimately 864. And so in terms of the guideline issue, even if the court was to buy the defendant's argument, and even if the court was to determine that the defendant should receive credit for that self-performed labor, the evidence was that that wouldn't change the guidelines at all. That would only...
Aren't you just really overthinking this whole thing?
It's very possible, Your Honor.
Doesn't it? It just strikes me that just because a person figures out a way to put more money in his pocket doesn't mean that the employer lost less.
Well, it does in this case because
Why?
of the facts of this case.
Why?
Because the way that CH Construction works is it's a general contractor, and it subcontracts out all of the work.
Right.
And so what happened here was that the defendant, one of the things he talks about extensively, and even in his own testimony, is that he did things like going around and cleaning up after the other subcontractors. Mm-hmm. Well, the testimony from the subcontractors, and even from Mr. Broglin, who was the defendant's witness, was that, yes, all of us are responsible for doing our own cleanup. And so the problem here is that part of the contract with each of the subcontractors is they will do this work, and CH is already paying for that to happen. And what the defendant did was he decided to go out and do this work on his own instead of enforcing the contract. And so what happens is CH ends up paying the full value of the contract to the subcontractor. And then they also end up paying the defendant his salary, which should have been used for enforcing the contract, and then they end up paying the defendant the amount that he felt was appropriate to pay himself for the extra work that was done that should have been part of the subcontracts. And that was the district court's finding, was that essentially he tried to double his salary by doing these tasks that he either should have been enforcing someone else to do or that were part of his duties already as the director of construction. And so that's the harm in this case, is the extra money. And again, that was illustrated by the fact that at the current time, the same work is being done with the same subcontractor that the defendant's company used, and it's being done for approximately a third of the price that the defendant's company was charging for it. And again, the government used that to illustrate the point that that is the money that the victim was out in this case, was that extra, what we essentially referred to as the overbilling in this case, was the markup of the services in this case. And it's a significant difference.
Right, so it was him figuring out a way to put more money in his pocket, correct?
Yes.
Right, okay.
Exactly.
But but that's what I can't understand in terms of the markup. It's a little confused to me because it seems to me that the district court could have said, should have just said that, no, I'm not concerned about all the things you said you did, or whether you did it or not. Not because whatever you did was owed to your employer, but even if you did those things, the evidence is that they were paid, you were caused the payment way above those amounts.
Right.
So that's what seems to me the disconnect is. But he discounted solely because I'm not going to give you any credit because you're supposed to do that. That's part of your job. But in this case is no. If you did it, it's still way above it because that was the evidence that we did the very same thing was done on all these projects, and we are way under him.
Right.
That's the point.
Exactly. And I do think that the district court made that finding as well when it found, it's in the memorandum order of forfeiture on 309 of the joint appendix. And that's where the district court specifically credited the testimony of Agent Hulser and said it convinces the court that the markup of subcontractor services was considerably higher than the prevailing market rate. And so I think that the district court sort of tried to reach it a few different ways. And it's admittedly not the most clear because he was trying to reason it out several different ways. And one of the ways that he found was that instance I just read, that the markup was considerably higher. And I believe earlier in the same opinion on 306 of the joint appendix, he says I think it starts out, the government maintains and the evidence appeared to confirm that Butler added a significant markup for the services performed by the subcontractor.
Right, that's the story right there because even if you did all of the work then, it didn't matter because we could have gotten all the work you did for less money.
Exactly.
That's the law.
Exactly.
Whether you did it or not.
Exactly. And the court stated it much more succinctly than I could have.
The district court make it more difficult than it had to be.
I think, Your Honor, as I said, it was a very long sentencing hearing. It was a 7-hour sentencing hearing. There was clearly a lot of issues that were being brought up, and the district court was trying to summarize as best it could all the evidence that it heard, make the finding various different ways. But certainly we agree with the court that finding is supported in the record, that is a finding that the court in fact made. And finally, I just would circle back to the point that the court made earlier, that this was a sentencing issue. The defendant pled guilty to mail fraud. He admitted that he hid ownership of the company. The district court drew an inference from that as well, that he used that inference to acknowledge the fact that these were inappropriate markups. Because why would you create this company, forge signatures on the contracts, hide your ownership of it, if in fact you're simply charging market rate for the service? The question here was, what was the fair market value of the services rendered? The district court determined that number. The number that the district court found was supported by the financial records, by the testimony of the witnesses. And we would ask that the court affirm on that ground. On count two, I'll simply add to on the second issue, I'll simply add to the defendant's argument that we do agree Blackman controls this case. Blackman controls the issue in this case, and we would ask that the court affirm the money judgment for forfeiture as well. Thank you.
Thank you. Mr. Burgess, you have some time.
On on one of the last things Ms. Mickelson said about the government, about the court crediting Agent Hulser's testimony about the markup. The markup is one of the columns on the spreadsheet. If you look at, I think it's just the spreadsheet that starts at A137, there's self-performed labor, equipment, vendor, material, fuel, markup. If the district court had said, I find that you get no credit for that specific column, then I think we'd have a much more difficult time. But the district court, and to be clear about the point I'm making, markup is something Butler put into put into his valuation where Valley would hire someone else and impose a markup. This is just a normal practice in the construction industry. And if Hulser said the markup was too high and the district court agreed with that, we're not necessarily challenging that on appeal, but that's not the whole case.
But don't you agree though? If the markup was too high, it doesn't matter how much work he was doing at midnight or overtime. That was their loss, wasn't it? Isn't that the end of the ball game?
No, I think we're reading the state. I think we're saying two different things by markup.
Yeah. 'Cause I understand a little bit about construction. In terms of markup, normally is your cost and your labor, and then after you get to how much it costs with your labor, then you say 15% on top of that. That's markup. That's the term is used normally in terms of markup.
Yes.
Which is appropriate. But the point is, once you find though that in those services the markup is too high, meaning on these contracts we paid way more than the market rate was. All right. Now, that being the case, no matter how much work he did to make sure things were done, the point is they paid too much money because they could have gotten that done at a lower price. Even if he did all of the work, they could have gotten it done at a lower price because that's the finding. It was way above market rate. I don't know why the district court goes any further. You have to go whether or not you had to do it, whether or not you were obligated to do it. That's of no moment. The point is they paid too much money. Even if you did the work and sawed and hammered all night long, they still pay too much money.
So I think two responses to that.
Yes,
One is I think the district court gave him just no credit at all for Butler's work. If he said you charge too much for it, that's one thing, but he said you get no credit at all. The other point I think is I think when they're talking about markup, they're talking about this column on the spreadsheet. They're not talking about the ultimate price that CH Construction paid Valley and Act. They're talking about the markup that Valley and Act purported to pass on to CH Construction when they hired subcontractors or equipment and that sort of thing, like equipment costs. So I think that may be part of the story, and if the district court had taken that out and not given him credit for it, we'd have a much tougher time, but that's not the whole story. To go back to the point Ms. Mickelson started with, two competing versions of the facts, the district court did not accept the government's version of the facts. He said at A617, I don't think they were shell companies, and he ultimately gave two legal reasons for rejecting Butler's side of the case. One was this part of the actus reus, and the district court says the determinative question is whether it distills to whether the admittedly fraudulent services rendered by the defendant, while lawful in nature, were legitimate or an integral part of the actus reus. That's a legal reason. That's not accepting the government's version of the facts, and that's wrong. And the other reason was this part of the contract business. And he said, assuming for the sake of analysis that Mr.
So why is that wrong? Why is that wrong? The actus reus is wrong. Why is that wrong?
It's the net principle we talk about. You don't get credit for work you did that's part of your crime. Mr. Butler's not asking for a credit for time he spent putting the contracts together or forming these companies or doing fraudulent things. What he's asking for is credit for the value he provided. And this is the distinction.
And that value was to cover up his crime because he knew that if he didn't do it, there would be some question about whether or not this was done properly on those jobs. Why is that not a part of the modus operandi? We're going to stick with Latin today.
Right, so we don't, right. So Mr. Butler has pled guilty, but I think that's a separate question. I mean, the best case that really encapsulates this is the Schneider case.
It's not a separate question. It's a different question, but it's not separate because it is a question whether or not the loss is within the res gestae of the crime.
The point here is that
Isn't that, counsel?
I'm not sure I'm able to keep up with the Latin. To circle back to your initial point, I understand where you're coming from. The idea that
the thing happening.
Yes, I understand your point that if he just simply taken the contract and not done anything, he probably would not have gone on like this for 7 or 8 years. But I don't think it follows from that he doesn't get any credit for this labor under that analysis. I mean, the distinction is probably best encapsulated in the Schneider case from the Seventh Circuit that we cite, where there's a distinction between a pure fraudster who solicits a contract, gets the payment, and then walks away and does nothing. In that case, the entire price is lost. And the other distinction is legitimate services provided in an illegitimate manner. And he provided legitimate services, and the district court accepted for the sake of analysis that he provided legitimate services. He provided legitimate services while concealing the origin of those sources and where the money went for those services, but they were nonetheless legitimate services. He built walls, he dug trenches, he pounded nails, did stonework, and there's no dispute. I mean, I don't think the government even disputed that this work was actually done and to a high standard of quality. They just disputed where this goes in the calculation. And there's another point I wanted to address. Is that even addressing even adopting our argument, Butler asked for $330,000 of manual labor costs, and that's not the whole. Even accepting that, the guidelines still come out the same. That wasn't his whole argument. He also talked about equipment costs. I mean, all the items are in the spreadsheet. I don't know the full details about the timing of when the spreadsheet was provided, but the notes underlying the spreadsheet were provided to the government in February 2012, which is about a year before sentencing, and that's the email enclosing that is at A231.
Those things weren't reflected in the corporate accounting as costs, expenses as judgment.
They were.
They weren't.
I think there was some overlap, but Valley and Act's records were not meticulous. They didn't reflect a salary. I don't think Valley and Act's tax records are good for us, and I'm not going to say that they are. But to respond at least partially to Ms. Mickelson's point, the spreadsheet was not provided to the government until the eve of sentencing, but the notes underlying the spreadsheet, which if you compare the notes and the spreadsheet, it's verbatim. The words are verbatim the same, with a few edits, and this is the expert's attempt to take that stuff and quantify it. And since it's the government's burden to prove the loss for sentencing, Mr. Butler provided the notes and thought, I'm giving you this information, the government would use it to meet its burden, and the government's position was this all amounts to zero. And, as I said beginning, I want to circle back to this, the district court did not accept the government's competing version of the facts. He expressed skepticism at various points in the transcript, but he assumed Butler's facts for the sake of analysis and gave two legal reasons for rejecting it. And as we've explained, we think those reasons are wrong. And that the court has no further questions. Thank you.
Thank you. Mr. Burgess, I note that you're a court opponent. I want to give you a special thanks. We appreciate your work. The court couldn't do its work without your able assistance, and we really appreciate that on behalf of the court. Mickelson, we also thank you for ably representing the United States here. With that, we're going to ask the clerk to adjourn the court, sine die, and then come down and greet counsel.